Hi, my name is Kyle Edgerton, and I'm with the Immigration Assistance Program at Catholic Charities of Northern Nevada. I want to talk to you about an important proposal that's pending in the federal regulatory system. I need your help, and so do thousands of families across the United States. As I'm sure you know, there are an estimated 10 to 12 million undocumented immigrants in the United States at this time. The vast majority of these people came here to seek new opportunities in a country that was willing to pay them low wages in exchange for their hard work. Although some of them were also brought here as children and never had a choice in the matter, and others were brought under other circumstances, including human trafficking. A lot of these folks came to this country without permission, so they are not eligible for a process known as adjustment of status. There are some exceptions, but for the most part, individuals such as these have to leave the United States before they will be eligible for an immigrant visa. This is the case even if they have spouses, children, parents, and other family members living in the United States as permanent residents or even U.S. citizens. This is the case even if they've been in this country for 10, 15, 20, even more years, and even if they were brought here as children. The laws are hard and inflexible. So we have a situation where tens of thousands of undocumented immigrants have been living in this country for years or even decades. They have U.S. citizen spouses and they've raised U.S. citizen children. They've put down deep roots in this country and they know it is their own, but they can't gain legal status unless they first leave the United States. Now, that wouldn't be a big deal, except there's a trap waiting for them. Upon leaving, they automatically trigger a 10-year bar of re-entry. That's right. Once they leave, they're kicked out for 10 years. And the only way to lift this 10-year punishment is with an I-601 waiver of inadmissibility. An individual can qualify for a waiver if he or she has a spouse or parent that's a U.S. citizen or a lawful permanent resident. Additionally, the family has to show that the qualifying relative, in this case the spouse or the parent, would suffer extreme hardship if the applicant weren't allowed to come back to the United States, either because the family would have to endure a 10-year separation or because the family would have to seek unity in another country. The standard for approving these waivers is quite high, and the courts have ruled that the hardship in a family's case has to be more than would be expected from the normal suffering that would result from a 10-year separation. Most families have to apply for a waiver more than once, and each decision takes several months. Now, all of this is built into the immigration laws, and it would take action by Congress to reverse the harsh standards it put into place in 1996. However, the President has proposed a change to this process and the way it works that could vastly reduce the suffering that these families face. Under the current system, the first step is filing Form I-130, which is the family petition. The second step is attending the immigrant visa appointment in the country of origin and receiving the 10-year punishment. And the third step is submitting the waiver application. From the time of the visa appointment until the waiver is finally approved, the family of the applicant must either live apart from their loved one or else relocate to a country they may never have known. Under the proposed rule change, the second and third steps would be reversed. Applicants could file for pre-approval of a waiver from the United States and then, if it is approved, return briefly to their country of origin before coming home to the United States as permanent resident aliens. This change could make the process much more predictable, less painful, and therefore more attractive to families. Overall, this is good news. The change is proposed Rule USCIS-2012-003. We're encouraging all of our clients, their families, and you to please take action in support of this proposed rule. Ideally, we would like to see the rule approved and even expanded in its final form, because in a lot of ways it's quite limited. The way it's currently written, it would only assist the spouses and underage children of U.S. citizens, leaving out the relatives of permanent residents and adult children of both citizens and permanent residents. The process would also not be available to individuals who are currently in immigration court or who have already scheduled their immigrant visa appointments. It would also cut out individuals who need more than one type of waiver. Please visit our blog for full details and for links to the proposed rule, to our comments in support of expanding and approving the process, and to find resources for getting involved. At www.regulations.gov, you can give your own input on this process, or you can join our comments by clicking on our petition at change.org. Even if this process doesn't affect you or your loved ones, or even if you've already gone through the current process, we still need your help. The I-601 waiver process as it currently is inefficient, it's unfair, and it's a nightmare that thousands of families have to wake to day after day, month after month, and year after year. Please help. Please like us on Facebook, follow us on Twitter, and check back here for more immigration updates. Thanks for watching.